For public bodies that are subject to Freedom of Information, or FOI, and Access to Information on the Environment, or AIE, it's really important to keep up to date with all of the latest decisions of the Information Commissioner and the Commissioner for Environmental Information. The Commissioner expects that these bodies will do this so that they can properly apply the exemption provisions under the legislation and respond to the access requests that they receive. The Commissioner has made it clear that this is expected of these bodies to enable them to respond to access requests received and to properly decide when the exemption provisions apply under the legislation. Some of the key Commissioner decisions each year are highlighted in their annual reports. So, for example, the 2022 annual report of the Information Commissioner was published in June 2023, and it highlights some key trends in FOI law. These relate to how to properly apply the public interest test when you're applying exemptions. Does the public interest favour refusing access to the information or granting access to the information? Two of the key decisions highlighted in the Information Commissioner's annual report relate to Section 29 of the Freedom of Information Act 2014. This is a discretionary exemption that allows an FOI body to refuse access to a Freedom of Information request if it relates to deliberations of an FOI body where release is contrary to the public interest. In the first case involving Trinity College Dublin, the Information Commissioner overturned the decision to rely on Section 29 because there was insufficient evidence of harm that would arise from releasing the specific records in question. The Information Commissioner also noted that much of the requested information was already in the public domain. In the second case involving the Department of Justice, the Information Commissioner again overturned the decision to rely on Section 29 to refuse access to information on an investigation under the Prisons Act 2007. Based on the specific content of the information, the Commissioner found that releasing it would not be contrary to the public interest. These two decisions make clear that there is a higher threshold for applying the public interest test under Section 29 than for other exemption provisions under the Freedom of Information legislation. To properly rely on Section 29, you must be able to show that releasing the specific information in question will cause detriment or harm that is contrary to the public interest.